afternoon, I am Natalia Ferre.
And I'm Sarah Hand.
This edition of the Georgetown Daily will cover this afternoon's proceedings of the Supreme Court case Rosenbaum v. Holder. Today, the Supreme Court justices issued their decision regarding the case. The decision was split 5-4, with the majority ruling NODA unconstitutional and agreeing with the buying and selling of kidneys. Robert Silverstein delivered the decision for the majority, and we have included the full opinion here.
Or otherwise transfer any human organ for valuable consideration for use in human transplantation if the transfer affects interstate commerce, and made such a crime punishable 5 years in prison and/or $50,000. The law defines a human organ as a human kidney, liver, heart, lung, pancreas, bone marrow, cornea, eye, bone, and skin, and any other human organ specified by the Secretary of Health and Human Services. As for the definition of interstate commerce, the law makes reference to the regulation within the Federal Food, Drug, Cosmetic Act, which defines it as 1. Commerce between any state or territory and any place outside thereof, and 2. Commerce within the District of Columbia or within any other territory not organized with a legislative body. The defense of Rosenbaum petitioned this case to the Supreme Court after the Circuit Court upheld the law on constitutional grounds. The Circuit Court found the act to be constitutional in its entirety, arguing that the law is valid under the Commerce Clause of the Constitution and that the Constitution protects the general welfare of all citizens, including the very poor. The prosecution argues that the Supreme Court should uphold this law, while the defense argues its client should be acquitted of the charges based on the conclusion that the law is unconstitutional. The Supreme Court holds that we reverse the Circuit Court and find Title III of Public Law 98-507, otherwise known as the National Organ Transplant Act of 1984, is unconstitutional, severing the section from the overall law. The defendant is hereby acquitted of all charges, and the rest of the law shall remain intact. This court, in its opinion, is not deciding the merits of the law, but instead views Title III of the National Organ Transplant Act of 1984 within the scope of the Constitution. The Feldman Court draws upon the Warrens Court landmark decision of Heart of Atlanta Motel v. United States, where Justice Thomas C. Clark wrote the court's opinion upholding the Civil Rights Act of 1964 power to ban racially segregated businesses. In this ruling, Justice Clark made clear the burden that Congress must meet in regards to application of the Commerce Clause. Quote, the determinative test of the exercise of power by the Congress under the Commerce Clause is simply whether the activity sought to be regulated is commerce within which concerns more states than one and has a real and substantial relation to the national interest. In this respect, the court concurs with the plaintiffs that the law reaches the minimum burden of the Commerce Clause. Indeed, in this case, the Commerce Clause protects Congress to legislate against perceived morality. In its rejection of business-sanctioned racial discrimination, Clark continues, it was this burden which empowered Congress to enact appropriate legislation and give this basis for the exercise of its power. Congress was not restricted by the fact that the particular obstruction to the interstate commerce with which it was dealing was also deemed a moral social wrong. Unquote. If Congress finds that a specific phenomenon such as racial discrimination, or in this case, a for-profit market for organ donations, inflicts harm on interstate commerce, we concur with the Warren Court that Congress has a constitutional right and, moreover, the constitutional duty to legislate to forbid such activity. Again, the Court repeats itself that it will not comment on whether compensating organ transactions are moral or not. We do not wish to take the role of lawmaking body or impede Congress's ability to legislate. In this vein, the Court was unsympathetic to the plaintiff's argument that the Court should uphold the law, uphold the defense conviction based upon perceived morality of the law. Although the Court, as sworn defendant of the Constitution, must rule protecting the, quote, general welfare of all citizens, there is no evidence that establishing a legal marketplace for organ transactions will cause irreparable harm to the country and the general welfare of every citizen. The plaintiff cited statistics from other countries such as Iran, where an overwhelming percentage of live organ donors regretted taking financial incentives to give up their organs. However, the Constitution does not necessarily concern itself with the outcomes of one's action. Does this mean the Supreme Court should ban steroid consumption because polls say 88% of American smokers regret picking it up? If one decides to donate a kidney for monetary gain, the government cannot predict the health consequences of every individual separately. We were also not persuaded by the arguments of altruism by the policy think tank. The Constitution does not mention altruism, selflessness, or volunteerism at all, and no section or amendment to the Constitution applies such. We feel the organ market maintains contention that altruism has no part of this conversation is accurate. Principally, the 14th Amendment guides our opinion. Section 1 of the 14th Amendment states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction of the equal protection of the laws. If the government infringes on one's right to constitutionally guaranteed due process, as it does in Title III of this Act, then this court has a prerogative and the duty to strike down said offending statute. All indications suggest that adding a law component to organ donations will increase organ availability. Commentators note Iran's success in solving its dearth of available organs for transplant. Forbidding an individual from pursuing the best available medical options, in this case acquiring an organ from a marketplace, violates his or her right to substantive due process. By not allowing someone to acquire a kidney, the government infringes on one's right to life and its liberty. Every year, roughly 5,000 people die in the United States waiting on a seemingly endless queue to receive a transplant. And this court finds that the government cannot ban a realistic alternative method to acquire kidneys that does not violate the rights of citizens. With respect to the donors, they have the right to privacy over their own bodies and freedom from government intrusion. The Supreme Court has already established a right to privacy under the 14th Amendment in Connecticut v. Griswold, and this court finds this case is consistent with Roe v. Wade and Lawrence v. Texas, where the court decided the government overstepped its authority. Furthermore, the Universal Declaration of Human Rights states, no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor or reputation. Everyone has right protection of the law against such interference or attacks. In this case, the government would arbitrarily interfere with a legitimate financial transaction and a legitimate medical need. The plaintiffs also failed to recognize that financial incentives for organ donation are already in effect in over a dozen states. States like Arkansas and Idaho not only give tax deductions, but they also give tax credits, which are direct financial incentives. Such incentives are well below market value, however, and a legalized market will likely correct such discrepancies and further encourage more people to donate. This court will not rule on the effect the marketplace for kidneys will have on the wealthy and the poor. Today, legislators and the federal government will undoubtedly set forth specific regulations to ensure the needs of its citizens are met. Our ruling should also not be construed to mandate the creation of such markets either.
Presenting the dissenting opinion, Brennan Kwan suggested that the selling and buying of organs is in fact unconstitutional, and that NOTA should be upheld. Here is Kwan's full opinion.
Rosenbaum violated the Constitution of the United States by orchestrating a market for kidney transplants, and should thus be held liable for either a fine of up to $5,000, up to 5 years in jail, or both, as outlined in NOTA. In the process, we have also decided that the National Organ Transplant Act, passed in 1984 by the United States Congress, is still constitutional. In passing NOTA, Congress established that it shall be unlawful for any person to knowingly acquire, receive, or otherwise transfer any human organ for valuable consideration for use in human transplantation if the Transfer Act affects interstate commerce. The defendants in this case claim that NOTA is in fact unconstitutional and that Rosenbaum should be freed of all charges. However, we as the members of the dissenting opinion found that after examination of the Constitution, NOTA agrees with the original intentions and objectives of the framers who created the legal foundations of this country in 1787. The very first sentence of the Constitution highlights the need to provide for the common defense and promote the general welfare of the people. By banning organ sales, NOTA is effectively protecting the general welfare of the American people, where the median household income is $50,000, the average household size is a little over 3 people, and 15% of the population lives under the poverty line. Although the middle class is shrinking, the gap between the rich and the poor is increasing. Facing the social pressure of providing better education and material goods for their families, men and women of low-income households would be incentivized to sell their organs for financial gain. Therefore, legalizing organ sales could be viewed by such households as a means to offset their financial deficiencies, ultimately leading to the victimization. The think tank referred to India, a country that once had a legalized organ market. In their system, it was reported that 97% of organ suppliers underwent transplants because of financial reasons. Although India and the United States are vastly different socioeconomically, it is possible that a similar pattern would arise as payment for organs would provide the poor with a financial catalyst to sell their organs. The plaintiffs cited Section 1 of the 14th Amendment in this defense, which states, "No state shall enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws." The argument here is that a person's body is his or her property and no one does not have a constitutional right to regulate what someone does with it. Additionally, under the Due Process Clause, no one cannot deny a victim of renal failure his or her right to seek life through a kidney transplant. In Roe v. Wade, the U.S. Supreme Court ruled abortion constitutional under the Due Process Clause in the Ninth Amendment, which guarantees a right to privacy. However, we find that there is not enough correlation between Roe v. Wade and Rosenbaum v. Holder to legalize kidney sales. The primary difference between these two cases is the risk attached to the corresponding procedures. In Roe v. Wade, the decision was to legalize abortion until fetal viability. The court noted that the principal reasoning behind the ruling was that before this point in pregnancy, the risks associated with an abortion is less than that of childbirth. The state can only intervene prior to fetal viability to protect the health of the mother when the risk outweighs right to privacy. As demonstrated by the ruling here, the state has an interest in the health of individuals. With regard to induced abortions, the risk of complications that require hospitalization is less than 0.3%. On the other hand, the risk of complications from kidney transplants, both physically and psychologically, is much higher. According to a study performed by Dr. Burkhard Ringe of Drexel University College of Medicine, he found that approximately 78% of organ donors had one or more medical or psychological complications. Due to this increased risk of both the donor and recipient, the Supreme Court has a right and duty to prohibit the sale of organs. In regards to the property right argument, we make reference to the prosecution's reasoning that the right to property does not transitively grant someone the right to sell a kidney. Prostitution and suicide, which were outlawed by the Supreme Court decision in Hope v. United States and Bacco v. Quill, respectively, were both deemed unconstitutional. As a result, just because one has the right to smoke, consume drugs, or treat his or her body in whatever manner he or she desires, there are certain instances when the government, having the intention to protect the general welfare of its citizens, may intervene on a citizen's right to his or her own property, his or her own body. We, justices of the dissenting opinion, would also like to note that our fellow justices of the majority do admit that the National Organ Transplant Act meets the minimum requirement for government to apply the Commerce Clause in its regulation of commercial activity. In this instance, we concur, and furthermore we assert that the prohibition of the sale of organs falls comfortably within the prerogative of Congress. We point to the collective holding of the Robbers Court, the National Federation of Independent Business v. Sibelius, that the Commerce Clause is intended to govern existing markets, which our fellow justices ignore. That the market for organs exists independently of its legality is self-evident, both in the history of the Prohibition era and by virtue of this case having reached the August body. Additionally, we find compelling the definitions of commerce established by the Rehnquist Court in the United States v. Lopez. Commerce consists of three elements. The first of these elements is that of the channels of interstate commerce, which is of no concern in this particular case. However, the second and third respectively govern the instrumentalities in both persons and objects in interstate commerce and activities that substantially affect or relate to it. In this case, the sale of organs, independently of their status in relation to their bearers, formally or not, may and must be construed as an act of commerce, which Congress has, as a majority of its cases, restricted in the rightful scope of its powers. In this instant, we might return to the precedent set by the ruling of the Stone Court in Wickard v. Philbin, holding that interstate commerce need not explicitly between the boundaries of the several states, as Congress may determine, and the subsequent ruling of the Rehnquist Court in Gonzalez v. Wright, which held that Congress has a right to regulate not merely commerce as individual acts, but also by extension regulate the market at large, implying that there is an extent right to a market for organs or otherwise. Secondly, it is the wish of the dissenting justices to address the citations to precedent made by our fellows in the majority. They have cited Hart of Atlanta Model v. United States, pointing out that Congress has the right to use the Commerce Clause in the pursuit of morality. While the majority has dismissed the international consensus against the sale of human organs as well as the philosophical arguments based on altruism as presented to this court, it is our opinion that regardless of the propriety and accuracy, constitute an atmosphere of sufficient moral gravity that Congress, by heart of Atlantic model versus United States, has a considerable interest in banning the sale of organs. The justices of the majority go on to justify their holding by the right of privacy, as implied by the due process clauses of the 5th and 14th Amendments to the Constitution of this nation. In particular, they cite the opinion of the Warren Court in Griswold versus Connecticut, in which the sale of contraceptives was made legal under the aforementioned principles. And here, our fellow justices suggest that the sale of organs is of sufficient import to be handled in the same fashion. However, our fellow justices forget that the specifics of the case of Griswold versus Connecticut, which banned not the explicit sale of contraceptives, but their use as per the moralistic laws of the state of Massachusetts. That their sale was banned was but a logical consequence of their having been struck down law. In this case, we hold that the transfer of organs is certainly legal, and as our fellow justices claim, of great necessity. Furthermore, if we were to argue that the transfer of organs was a private consideration of citizens, we still hold that the side of these organs, being by definition public and of sufficient consequence as to concern the legislator of this nation, falls within the purview of Congress's power under the Commerce Clause. In conclusion, we, the dissenting justices, recognize the unfortunate reality that renal failure and the subsequent need for kidney transplants will continue to become a significant issue in the future. We acknowledge that if NODA continues to exist within any further interventions, the waitlist for kidneys will continue to grow as the number of donations diminishes. We dissenting justices propose an alternative form of compensation for kidney donors that will incentivize more people to donate while not directly paying for the organs. For instance, tax breaks are awarded to those that donate to charities. Ideally, this form of compensation will incentivize members of all economic classes to part with a kidney without paying donors directly, which we, as members of the dissenting opinion, believe violates the very Constitution which we are charged to uphold.
We had the privilege of being present at the court's hearing and were able to interview defense lawyer Fabiola Delgado and prosecutor Kian Chong regarding their thoughts on the ruling. How do you feel about this court decision, the ruling?
Well, I'm really happy that the defense won and that our arguments were heard, and that this NODA act is completely unconstitutional, and that citizens of the U.S. will have the right to sell their kidneys if they want to.
That's great to hear. So, Key, how do you feel about today's ruling?
It was a very close ruling. I think Neil and I actually agree with the justice's ruling. Especially the last bit, we agree that as it stands, the court has come to a very wise and judicious judgment when they argue that it doesn't have to be this specific way of legislating, and therefore it was unconstitutional on the basis of the 14th Amendment.
Thank you for following this case of the Georgetown Daily. Please be sure to follow the #1 news source here on the Hilltop.